Theodore Edgecomb, 20 CF 3535. Appearances.
Grand shooter for the state.
Morning, Your Honor. Edgecomb on behalf of Theodore Edgecomb.
Yairi Lamar on behalf of Theodore Edgecomb.
Mr. Hubner, so it doesn't get ugly as we argue, grab the microphone, use it, please.
Oh, sorry, I put it up on the podium. Trying to be proactive, I apologize.
All right, it's just after 9 o'clock, the jury's back. There's possibly one or two things to discuss, then I'm going to instruct the jury. Both sides will make closing arguments. I think the state suggested an hour, the defense suggested an hour and a half. I'll allow up to an hour and a half maximum. That's a hard stop at an hour and a half. Again, both sides hopefully are aware that you don't necessarily have to use the hour and a half, and sometimes, if not most times, not spending too long on a closing is advisable. We discussed yesterday the instructions that the state submitted. I don't know if either side has anything to add on that. I believe it was the defense that drafted a proposed additional instruction. Is that correct?
That's correct, Your Honor. I made some additional edits after speaking with Attorney Hubner. I'm about to email our final draft of that to the court and to Attorney Hubner. I don't believe there's an objection on it.
Well, I guess I need to see the final draft, but Mr. Hubner?
Your Honor, I don't necessarily have an objection to it. I just raised the concern that the defense counsel's version had the court explicitly telling the jury about the tragedy in Waukesha, which I thought was potentially...
Is no way going to happen. I don't need our argument from either side. No way on God's earth am I going to allow a sentence that says, finally, evidence was received that the defendant was on bail at the time of the charged offense. Any recent events in the neighboring county of Waukesha shall not affect your deliberations in any way, and you are to decide this case solely based on the law and facts presented to you during the trial. Mentioning that situation in Waukesha, I presume, obviously that's a reference to the Brooks case, arguably one of the biggest tragedies and worst crimes this city, or I should say state, has seen in the last decade. I mean, no way. It's hyperbole, it's inflammatory, it has nothing to do with this case. It would potentially distract the jury, not a chance. So as long as that's out, let's get me the revised version, please.
And Attorney Hubner.
As far as the special instruction, the second paragraph that's proposed and the third paragraph, I don't particularly have a problem with. I think they accurately portray the situation and accurately state the law. I want to hear the state's position on the first paragraph. The first paragraph reads, evidence was received in this case that the defendant had other open cases at the time the offense was committed. You are not to allow this fact to affect your deliberations on the defendant's guilt or innocence as to the charged offense in any way. Does the state want to comment on that? You know, my concern is the defendant discussed some of those open cases because, as I said yesterday, he clearly opened the door. I think the defendant feigned ignorance on his multiple criminal cases. The parameters were drawn multiple times by this court in pretrial motions and in conversations off the record, and the defendant on multiple occasions, I think, feigned ignorance or was making a speech to the jury saying he knows nothing about the fact that he had two criminal cases with two separate criminal defense attorneys. So it goes to veracity. So saying that that's not a factor, I don't know.
Maybe, Your Honor, then the best way to do it is to leave the first sentence as is, and the second sentence should just state that evidence was received only as it applies to the defendant's credibility, and it should not be used for any other purpose.
I think that's better. It's a credibility determination, Mr. Ahmad. Your client put that in issue. His credibility was put in issue by his repeated denials and repeated conflicting testimony. It is an issue. It affects his credibility. So if you want to modify that sentence, fine. I want the jury in here. I want to instruct them. I want closings done. Say that again, Mr. Huebner, please.
That evidence was allowed only as it pertains to the defendant's credibility, and it should not be used for any other purpose.
I think with that modification and the other modification to the last line, it's acceptable, and I'll give the instruction being requested by the defense with those two modifications.
There's a couple of other issues, Judge, for closing instructions.
I will debrief.
Number one, we are requesting, based on the case law, an instruction for negligent homicide. That's under 1175, homicide by negligent handling of a dangerous weapon. The testimony or the basis for that is during cross-examination, I believe, there was some clarification questions asked by Attorney Huebner about how the gun had just gone off, and then...
But then, Counsel, I apologize for interrupting. Then arguably we take self-defense off the table, and I won't instruct on self-defense.
So, Judge,
Then it's just an up or down, guilty or not guilty on the counts. Because your client, I mean, arguably, as I thought about the testimony yesterday, there were statements made by your client that could lead a jury to at least consider and possibly believe the self-defense claim. But as you know, he repeatedly insisted on direct and cross that yes, the gun just went off, acting like it was somehow an accident. So I'll hear from both sides, but I don't see how negligent homicide fits with self-defense. In fact, Mr. Huebner?
Well, I think Mr. Ahmad wants to finish his argument, and then I'll respond, Judge, if that's okay.
Okay, go ahead.
Judge, State v. Carroll, Watkins, 244, Wisconsin 2nd, 205. It's a 2002 Wisconsin Supreme Court case. It was a review of a decision of the Court of Appeals, and basically the Wisconsin Supreme Court said those two concepts are not mutually exclusive, which is specifically self-defense and then negligent homicide. If there was some facts in that case where the court found that there was a basis for both, and that's just an issue for the trier of fact. That was a court trial in the original case, but essentially it's no different. It's a jury question as to how they want to resolve all of these charges. They're already going to be receiving the lesser includeds, so they're going to have already 4 different homicide degrees to consider. There is some evidence under the some evidence standard also if they decide to resolve the case for an accident, according to the defendant's testimony, which is testimony that was developed further by the state, then I think that's also been put into issue. I think the state's argument, Judge, is going to be that, well, in the Watkins case, there was first some assertion of the threat of force, and followed by then an accident occurring, perhaps, from a struggle between the parties. In this case, the facts that would support that would be there was some testimony about Mr. Edgecomb telling Mr. Cleereman to stop, and then he approached, and then Mr. Cleereman had his fists up, and we saw the video, and we've seen that many, many times in this case. There was a lunge, and then there was a very quick discharge of the weapon. I think there was some evidence that there was a showing of the threat of force, and obviously it's not the same exact case, but there is a basis to have the jury also look at that charge and consider it in deliberations.
First of all, Your Honor, I don't believe if you are to go to accept what defense counsel is stating regarding the Supreme Court case, it's not the same. In that case, what happened was the individual pointed the firearm in a deliberate show of force. This defendant, according to what the defendant all of a sudden came up with at the 11th hour, was that he didn't. He says stop, but he never shows the gun. He never points the gun. He supposedly has it down at his side. And then he doesn't even necessarily say, defense counsel, I think, was trying to get him to say that he aimed it. Never necessarily even said that. He says he backs up and it goes off as the victim is supposedly lunging or trying to spear him to get the gun. I also do not agree that the video shows a lunge. The video shows the victim literally collapsing.
I do not see a lunge on any of the videos that were played multiple times. I did not see anything that was close to a lunge. The jury's the finder of fact, but I did not see a lunge.
I mean, it's up to the jury. But based on these facts, Judge, in that case, they're not mutually exclusive. In this case, they are. There is not a situation in which what the defendant testified to is consistent or even comes remotely close to the intentional use of force or even show of force. According to him, he didn't do anything. So they are mutually exclusive, even under the case that defense counsel cites. So self-defense would not apply if you have this negligent homicide. I would just also note that in order for a jury to acquit on second-degree reckless, which is they'd have to get all the way down to second-degree reckless, no utter disregard for human life, no intent, they get down to second-degree reckless. In order to get from second-degree reckless to homicide by negligent use of a dangerous weapon, the only difference between those two is reckless requires, and just so we have it 100%, that the defendant in that situation was aware that his conduct created unreasonable and substantial risk of death or great bodily harm. In negligent, it's just that he should have been aware. Well, he admits to having weapons training. He admits to knowing that there's going to, about the weapons.
Read that distinction again, please.
Sure, Your Honor. And I pulled up the. Let me just pull up the actual jury instruction that separates the two of them, because if we're looking at this, the difference between criminal reckless and criminal negligence, this is from the jury instructions, both require conduct that creates an unreasonable and substantial risk of death or great bodily harm. Criminal reckless requires that the person engaging in the conduct be aware of that risk, while criminal negligence requires that the person engaging in that conduct should have been aware of that risk. In this case, I don't think there's anything that puts that portion of it at play as to the difference of whether or not the defendant did or should have known. He states he has weapons training, and I don't necessarily know that's in play. I would just note, if defense counsel was going to do this, the least thing they could have done is draft it for us. If the court wants to add it, I'm working on it now.
I agree with the state. I don't think under that case, I don't think it's the same. I don't think it applies. I don't think it applies based on the facts and the testimony. The state makes a salient point somewhere out of nowhere on redirect to defense questioning. Somehow, I think it was a surprise to everyone, the defendant says he has weapons training. That's a very salient point. I'm not giving negligence. If the defense has given or modified that last sentence or two on the special instruction, email it to my clerk, e-file the final version. I guess you can e-file the other versions just for the record, but then I want to bring the jury in and give them the instructions, which will take a bit, and proceed to closings. Did the defense modify that special instruction, please?
Yeah, I did, Your Honor, and I did e-file that and submit that.
All right, hang on a second. All right, 2-minute recess. My clerk's printing. I've got a jury waiting, gentlemen. Mr. Huebner.
I'm willing to allow the negligent, although self-defense wouldn't apply to it under the theory that the defense is trying to get it in this situation. So it has been modified that way. Then after I did that,
Use the mic. So can I characterize it as reluctantly stipulating to the instruction on negligent homicide?
Yes.
Fine, because as I said off the record, I was not going to give it. I think the decision in Watkins, which I glanced at yesterday and had a bit more time to review while we were off the record, is a different situation. But if the state's stipulating, fine, I'll give the instruction on negligent homicide. Now I think we've reached a point where literally the jury can consider every form of homicide that exists in the Wisconsin statutes, correct? Am I missing one?
felony murder, you're missing felony murder. I'm not asking for felony murder. So
Well,
other than
please
that-
don't, because we've already given 5 of the 6 possible homicide instructions that exist in Wisconsin. I'd like to not set the world record for lengthy jury instructions. Mr. Mott, I hope we're done discussing this. Is there another issue?
The last issue, placing on the record, state's objecting, but I think if we're doing the negligent, then the accident 772 should be given. I know this. The accident 772 instruction should be given based on what was elicited in cross. I know the state's objecting to that.
Mr. Hubner?
Your Honor, accident is him trying to state, the defendant trying to allege that he did not have the mental state in order to commit the negligent. If their whole point is that it was criminal negligence.
Let me jump in. I'm not clear what the point is at this point. Maybe it'll be illuminating to listen to the closings, and the jury is the ultimate arbiter. The jury will consider the evidence. The jury will render a verdict. But I'm extremely confused by the point the defense has been trying to make. They tried to make one point for an entire 6 or 7 days. Then their client took the stand and basically changed what was being implied, if not directly argued to the jury. Mr. Edgecomb did everything he could yesterday to say, the gun just went off. So I'm not clear what point the defense is making. Maybe we'll find out at the closings.
Anyways, I don't think accident applies with this fact pattern. It applied in that other, in the case the defense is referring to. It doesn't apply to this. The defendant is not disavowing the mental state. In fact, he's in fact stating he had the mental state, especially based on his weapons training. So therefore, sorry, I'm trying to get
I don't blame the state. By the way, gentlemen, we discussed a lot of this yesterday. We spent 45 minutes on instructions yesterday. It's frustrating when the defense adds all these additional requests on the morning I'm going to instruct the jury. I told the jury to be here between 8:45 and 9. They were all here by 8:45. It is now 10 o'clock. It benefits no one, and it is not fair to a jury to have them sit in the jury room hour upon hour.
Thank you.
Instruction 772, accident, does not apply, and I'm not giving it. That request is denied. So, give me a minute, as we've now done, I think, 4 separate versions or 3 or 4 versions of the instructions. Hang on. All right, having the jury brought in. Everybody can remain seated and silent, not just when the instructions are being read, but during closing arguments and the like, please.